Ladies and gentlemen, welcome to the 18th treatise. Now, today's topic is informed by happenings in Kenya consistently after elections, which historically has proven that the Kenyan electoral cycle is a process that takes around 2 years. We normally have around 2 years captured in serious campaigns, and ultimately the elections, which in most instances end up in chaos, mayhem, resulting in deaths, resulting in riots, resulting in destruction of properties, resulting in the running down of the Kenyan economy, a fact that affects so many Kenyans within this electoral cycle. And it is on that basis that we are saying, pursuant to today's treatise, that there must be a solution to this. Now, my position, as I am postulating today, is informed by the fact that the standards for annulment of elections in Kenya, and especially the presidential election, as we captured in the last treatise that we had, is clearly captured in section 83 of the Elections Act. And remember, in our last treatise we talked of the two limbs that ought to be demonstrated, and the fact that pursuant to the decision in the Raila Odinga petition by the Supreme Court in 2017, all that one needs to demonstrate, the standard that needs to be met before a presidential election is annulled, is any of the two limbs. If you can demonstrate any, then of course the court can comfortably annul that presidential election. And so out of this argument, you will realize that it would seem that, unlike in other jurisdictions, unlike, for example, in the American jurisdiction, where you will have to demonstrate the two limbs, and particularly the fact that even if there were electoral irregularities and illegalities, but then you must show that those irregularities and illegalities ultimately affected the final result before a presidential election result from within the American jurisdiction can be annulled. Now, you find that if you compare that with our position in Kenya, then it would seem that, and I want to say this cautiously in quotes, it would seem that it is a lot more easier to annul a presidential election in Kenya than it is in the United States of America, and of course also in numerous other jurisdictions. And it is important to note that because of that threshold that was set by the Supreme Court in 2017, it therefore imposes a heavy duty on persons and on bodies that are tasked to the responsibility of conducting elections, and I have in mind the IEBC, to ensure that that election is done in a fashion that meets the threshold as envisaged under the Constitution and as well the electoral laws. And you remember last time we talked of Article 81 and 86 as capturing the principles that must be adhered to when conducting elections. We also cited various sections of the Electoral Act, and when you're talking of presidential elections, in addition to the principles under Articles 81 and 86, remember there is also Section 39(1) subsection C of the Elections Act number 24 of 2011, in respect of the simultaneous transmission of the results to the constituency and national tallying center. So that what comes out is that the burden that is therefore vested, the task that is therefore vested upon the IEBC is so crucial, it's so mundane insofar as the safeguarding of our democracy is concerned. It is such that it is unacceptable that after having an electoral process and cycle that is ordinarily captured with around 2 years of campaigns, and ultimately having around 17 million people lining up to cast their ballot. It's unbelievable, and it must not be taken for granted. It's something that cannot be acceptable and allowed, that in the end of the day, that election that is done on that one day ends up being bungled, such that again it has to be annulled by the Supreme Court, so that then Kenyans will then find themselves again in another cycles of campaign and elections, which are ordinarily mired by chaos and name it. So it is on that basis that we are saying, and seriously so, that in as much as in the last presidential election petition 2017, the IBC was heavily indicted by the court insofar as how they conducted that election. It is important to note that the IBC is a constitutional body established pursuant to Article 88 of the Constitution, and as well as the Elections Act. However, it is individuals who would run the show within the IEBC. Yeah, it is individuals who bungle elections. It is not that body per se. It is about individuals. It is about the individuals that we task with the responsibility to run the show within the IEBC. And it is our proposal, and that forms the basis of the argument that we have today, that we must amend our laws in such a fashion that persons that are found culpable within the electoral body to have bungled elections, even if it is the commissioners within this entity, even if it is particular officials who are employed within this entity, then these officials must be made to pay both in terms of costs and also damages. Yeah, and that has to be individual. They have to be individually culpable. And why do I bring in this line of thought and argument? You will realize, and that is interesting, that within a jurisdiction like in America, and you can have a look at the renowned presidential Supreme Court decision on the George Bush versus Albert Gore presidential election that was basically pegged on the results as accrued from within the Florida state. Then you will realize that within that jurisdiction, in fact, there is no there is no particular single constitutional body that has been tasked with the responsibility of managing elections. Yeah, in fact, the task of managing the presidential vote, insofar as determining who in the end of the day will secure the electors within individual states, is left to the legislatures in particular states, such that if you go to a state like Florida, that task is vested specifically on a governor's appointee. The person is the cabinet, the state secretary of Florida, who is an appointee of the governor. And you realize that ordinarily governors are elected democratically through elections, such that it's there is always that possibility that a governor would come from different political parties depending on the wave during any particular election, and that governor would then be the one to appoint one of his officers as a state secretary, and it is that person from within the context of Florida would then be vested with that authority of manning elections. And in this case, the presidential elections, in terms of determining who will win and secure the 25 electoral votes within the Florida state. So that it then turns out that to hold proper elections, to hold free and fair elections, in as much as there are systemic problems that ought to be designed from within the context of institutions. But what is more fundamentally important is that the individuals that have been tasked with the responsibility to run the show in terms of the elections must be persons who have high aptitude, and not just that, they must be persons who understand the vital role that has been placed on them by the constitutions of their particular countries. And I dare say that whereas within the context of the American jurisdiction, it is unimaginable that you might find, such officials as I have mentioned deliberately putting in place mechanisms to ensure that elections in their countries will be bungled. Unfortunately, and that's what has been demonstrated in Kenya, we have had public officials within the IEBC who, it would seem, deliberately put across mechanisms that would ensure that after 2 years of painstaking campaigns, that in the end of the day, the elections that would be captured by millions of Kenyans lining up to vote would be bungled, and the result that would occur ultimately is one that would be susceptible to annulment by the Supreme Court. And why do I say so? I mean, if you look at the decision by the Supreme Court in the Raila Odinga petition 2017, you find that the IEBC was seriously indicted for, amongst others, one, and I want you to look at this keenly, the fact that the IEBC deliberately put in motion a system that ensured that by the time of going to elections, around 11,500 polling stations were devoid of either 4G or 5G network that would then facilitate the transmission of results from those 11,500 polling stations to the National Tallying Center. Now, you realize that this is one thing that should not have been stomached at all. Why? Because the very same regulations under the elections regulations 2016 was such that the IEBC was expected to make such safeguards in terms of network within 45 days to the election, so that for that body to come up 2 days to the election and then state that 11,500 polling stations would fall outside the network is just unfathomable. It's just unbelievable. It's just flabbergasting. And to make matters worse, I want you to bear in mind that if you look at the thresholds for annulment of the presidential election, and I have in mind the first threshold under Article 83, where you are saying that so long as you can demonstrate that the process, as it were, substantially went contra the constitutional provisions, constitutional and as well as electoral law provisions, then if you look at just that point alone, the mere fact that the IEBC or individuals with the responsible individuals within IEBC could allow a scenario where we go to elections with 11,500 polling stations, which account for around 3.5 million votes, not being in a position to be transmitted to the National Tallying Center, contrary to Article 81 and 86 of the Constitution, as well as Section 39(1)(c) of the Elections Act, then that in itself was enough ground to annul that election. In fact, it did not matter who won the election, whichsoever party won the whichsoever party lost the election, who would have lost that election, definitely on that ground alone, in filing a petition, would have succeeded in having that election annulled. Of course, we also have other numerous instances, for example, where court orders are issued by the Supreme Court to the IBC to provide certain documents. And for example, when orders were sought for the providing of all the Form 34A and B in read-only setup, or with an alternative to have the same copied for all the polling stations, and that basic thing could not be furnished to the Supreme Court. So that the question that I'm therefore raising is, if individuals that are tasked with a constitutional responsibility can deliberately make such moves which would, as it were, lead to the compromising of the sovereign will of the people, compromising of the core act of election, which is a central process in an electoral cycle, then the thing is, such individuals must not be let to go scot-free. What I'm saying is that we must have a mechanism, we must relook our laws such that we craft an amendment wherein individuals who are found culpable will then be made to meet the consequences in terms of pecuniary damage, in terms of costs, such that it must be made difficult for individuals to attempt to compromise our elections. Now, emerging jurisprudence from various jurisdictions have in fact supported that line of argument. If you look at the Malawi Supreme Court decision in the presidential election petition, presidential election petition application number 1 of 2020, in the case of Professor Mudarega and Dr. Shakera, you will realize that one of the comments that was made by the Supreme Court is the fact that an election is so mundane, is so critical, such that it cannot be acceptable that individuals who are tasked with the constitutional responsibility to man it can deliberately bungle it. In fact, the court said that these individuals, the electoral body, is a duty bearer. It actually ought to be neutral during election petitions. Its role ought to be basically to provide the truth, to help the court in arriving at the truth. Its duty should not be to hide information from the court and from the people of, the people of the country. The court, in fact, went ahead to say that the court fell short of, asking and imposing penalties in terms of costs and damages, compensation upon the commissioners of the Malawian electoral body. And I'm saying that I want to believe is the nature of jurisprudence that we need to adopt and which needs to inform the interpretation of our Elections Act. In fact, if you look at our Elections Act, at section Elections Act number 24 of 2011, and principally at sections, I believe, should be 84 and 87, you'll find that section 84 talks of award of costs. That is in the event that a petition or wherever it succeeds or otherwise, but there's a provision for the award of costs. And then, of course, next at section 87 talks of instances where there are malpractices of a criminal nature, which have been established by the court. Then the court would recommend the same to the Director of Public Prosecutions, who would then be under duty to initiate investigations and, of course, prefer a prosecution. But I would want to state that you'll realize that the malpractices that were clearly committed by officers of the IBC, as found by the Supreme Court, are such that, in as much as they might not fall within the context of criminal actions, but those are malpractices which definitely show particular individuals within that particular system deliberately put in place mechanisms that in the end of the day ensured that the elections, as it were bungled. And therefore I think that, and I would recommend that going forward, we need to find a formula through which either that particular section, that is section 84, and as well as section 87 of the Elections Act are amended so as to, bring in the aspect of culpability upon electoral officials and even upon commissioners, where it has been specifically established that they deliberately bungled our elections. Yeah, I know there's a sense in which there is immunity upon officials of the IEBC, as especially where they do their work, in a scenario where they honestly believe to have been acting in good faith. But you are saying that where it has been established that there were deliberate lapses which cannot be excused, then such officials must be made to pay individually for what they have done. It is not enough to cause the IEBC to be paying costs when, after such elections are bungled, because in any case the IEBC is a constitutional body. When it pays costs, it's Kenyans who are paying costs. Yeah, so an individual bungles the elections, and after bungling the elections, which affects the lives of Kenyans, the same Kenyans are then the same ones who are then occasioned to pay costs that have been, lumped up upon the IEBC. So we are saying that this is an aspect that needs to be relooked. We are saying that it is important that we carry out an amendment of that particular or those particular sections of the Elections Act, and that an interpretation of those particular sections ought to be made which is holistic, which is purposive, yeah, and bearing in mind that persons vested with that sort of responsibility play a very important role in the country, and it is such that any lapses on their part are enough to compromise other rights of so many other Kenyans. As we have seen, whenever you bungle elections, you cause loss of lives. Whenever you bungle elections, you cause loss of property. Whenever you bungle elections, you disrupt the economy. Yeah, so many Kenyans to date are still reeling out of the consequences of the last, whatever transpired during the last elections. And I think it is high time that we ensure that even as we approach 2022, we must put in place mechanisms that will ensure that the electoral body will not fail us again. I dare say that the way out of this thing is an amendment of the Elections Act in such a fashion that will bring individual culpability in terms of the payment of costs and damages, and this must be placed upon commissioners and even electoral officials within the IEBC who have been established as have been culpable by the courts. Thank you.